progress.
These ones been done since we kind of got sick.
But the court's going to take up cause number 1000. This is in the interest of let's see, Gerard, Medina, Harley, Arts, and Jayla Arts children. The case is set for a hearing on a show cause hearing filed by the Texas Department of Family and Protective Services. The hearing is being conducted today pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is caseworker, investigator Jackie Ledbetter, caseworker Evelyn Ivey, supervisor Crystal Gillette, and the department's attorney is Christine Rankin. The mother of the child is Samantha Arps, and I don't show her on my screen at this point. The alleged father of the children, Harley and Jayla, is Edmund Ortiz, and I also do not see him on the screen at this point. The alleged father of the child, Jeriah, is Justin Medina, and I believe he is participating in the hearing today. The court has appointed Gerald Ratliff as attorney ad litem for the children, and Mr. Ratliff is not present due to a court conflict. I believe James Valencano is present as the guardian ad litem for the children, and the court is excusing the children from participating in the hearing today. Y'all stand by. I think, I believe maybe the mother of the children is about to join us here. A second. All right. I see a young woman on a device called Sam phone. I'm assuming that's Samantha Arps. Is that correct, ma'am? Okay. Can you unmute your device, please? Okay. The record reflects that Ms. Arps is also present in the virtual courtroom. Ms. Rankin, in reviewing the court file, do you have evidence that Mr. Ortiz has been served at this point?
They told me that he was served.
I'm sorry, ma'am. I'm sorry. I'm talking to Ms. Rankin now, ma'am. Thank you.
I'm sorry.
I don't believe so, but if you'll give me one moment.
Okay, thank you.
We have not received a copy of the citations back from the sheriff's office on Mr. Edmund Ortiz.
Thank you. All right. Ms. Arps and Mr. Medina, the Department of Family and Protective Services, Child Protective Services, has filed a petition seeking to be appointed as the temporary managing conservator of the children that are the subject of this suit. The hearing today is a show cause hearing, and the purpose of the hearing is to determine whether or not the court should grant the orders requested by the department. If the court were to grant those orders would include an order that would appoint for the time being the department as temporary managing conservator of the children, meaning the department would have the duty and responsibility to make sure the children were in a safe environment while the case continues. The orders would also include an order for Ms. Arps to be appointed as a temporary possessory conservator, meaning you have quarter rights of visitation to your children during the course of the case for whatever its duration. That would be arranged through the department. It would provide for paternity testing to be conducted to resolve whether or not Mr. Ortiz and Mr. Medina are in fact the fathers of the children that they've been identified as an alleged father. The orders would also include orders that would require the department to provide services to each of you to try to address any concerns the department may have if the children were back in your care, and it would order each of you to participate in those services. If the court were to enter those orders, then the court is required to set additional hearings in the case to check on the status of the case to see how the department is doing on providing services to you, how you are doing on participating in those services, how the children are doing, and whether the issues that prompted the court to file a suit have been resolved, where the children could be back in the care of a parent. If the court were to enter those orders, the department would place the children. Ms. Rankin, do you know where the department is proposing the children to be placed at this time? Ms. Rankin, do you know where the children would be placed if the court were to grant the orders requested?
I would have to ask Miss Ledbetter.
Okay, Ms. Ledbetter.
We do not have any placement options at this point. We would be looking at foster care.
And under the law, the department has, if it's appointed, can appoint or place the children in foster care, but they are obliged, if the children are removed from a parent, to try to identify any potential relative placements that the parents can identify, and if the placements are appropriate on a temporary basis, the children can be placed in their care. In any litigation, you have a right to retain a lawyer to represent you in the case. Ms. Arps, and as a parent in the case, you also have the right, if you are unable to afford to hire an attorney, for the court to appoint an attorney to represent you. And I have in the court file an affidavit in support of a request for a court-appointed attorney, which it appears you have completed. And it's my understanding that you are requesting a court-appointed attorney. Is that right?
Yes, sir.
Okay. And the information that was set forth in that affidavit is true and correct. Is that right? I'm sorry, ma'am. You're going to have to speak up. I can't hear.
Yes, sir.
It is? Okay, thank you. Well, I'll find that you qualify for a court-appointed lawyer, and I can appoint an attorney to represent you as the case progresses. Mr. Medina, you are identified in the department's pleadings as an alleged father, which means that for legally you've not been determined to be the father of the child, according to the department's pleadings. As an alleged father, you're not technically a parent. I'm not authorized to appoint an attorney for you. I do see that you have filed an application for a court-appointed lawyer. I cannot appoint one for you. You certainly have a right to retain a lawyer to represent you in this case, including before this hearing proceeds. Since Ms. Arps has qualified for a court-appointed lawyer, I'm going to appoint a lawyer to represent her, and I'll reset this hearing for a later date. So you'll have a time to try to retain a lawyer if you wish to do so before you proceed with the hearing in this case. But I'm not authorized to appoint one for you. Now, if you are later determined to be the father of the one or more of the children in the case, and at that time are opposed to what the department is wanting to do in the case and cannot afford a lawyer and can establish that, the court can appoint a lawyer for you at that time. Thank you.
Judge,
Yes,
I
sir.
did receive a citation,
Okay, I'm sorry.
a return citation just now for Mr. Edmund Ortiz. And
Okay,
it
well.
looks like he was served. on, I believe, June 25th.
All right, thank you. All right, Mr. Medina, did you have a question?
So if I get a DNA test on my son before this next hearing, y'all can get me a court-appointed lawyer?
Well, if, yeah, in theory, if a test can be done, I doubt that you'll get one done that quickly. But if you were able to, if your paternity were established, then you can make an application for a court-appointed lawyer. Now, whether you would qualify for a court-appointed lawyer would depend on your assets and income and ability to pay for one. But I'm just not authorized to appoint one for you until you're established as the father of the child. So if you are not established as a father of the child prior to the reset hearing, you'll be proceeding either representing yourself, or if you've retained an attorney, you can your retained attorney can represent you at the hearing. So,
Judge, may I make a suggestion?
yes, ma'am.
Well, the attorneys general does take quite a bit of time for getting the testing done. If Mr. Medina were to take the child, or arrange to have him and the child tested at any lab now in Abilene, that is also one I believe we've used in the past. And they may be able to have paternity testing done a lot faster than the attorney general's, but I believe it's probably it's somewhere between $300 to $500.
All right.
So, Mr. Medina, you can discuss that further with the department if you want to try to choose that option. If you don't, as part of the proceedings in this case, if the court were at the time of the hearing to grant the orders requested by the department, the court would enter an order that would order paternity testing, and that would be conducted through the Texas Attorney General's office, and they would make a determination through them if you were determined to be the father. So, all right, thank you. All right, I'm going to reset this case for a hearing on the earliest setting I have is August 3rd, 2021 at 4 p.m. I'm going to reset this for that date. Ms. Arps, I'm going to appoint Andrew Graves. He's an attorney in Congress in Stangelo to represent you. He'll be notified of that appointment, and you'll need to confer with him about your case and your position in it, so you can be prepared to proceed at the time of the reset trial or the reset hearing. Y'all will need to stay in touch with the department to make sure you get a copy of the Zoom video conference link for the hearing, so you can participate at that time. All right.